9 o'clock, and it's time to call the Board of Examiners for Surveyors meeting to order on the 17th of April, 1915. Notice of the April 17, 2015 meeting of the Board of Examiners for Land Surveyors posted on the Board of Examiners for Land Surveyors website on April 1st, 2015. All right, to all of you that are here with us this morning, thank you for coming to be with us and welcome. We will get to your point on the agenda whenever that is. We're going to first adopt the agenda and then we will proceed with our meeting. An opportunity to take a look at the agenda, and Donna sent that out. I don't know if there's anything that you need or strike from the agenda at this particular point. Keep in mind if we add anything to discussion, and no vote can be taken on anything added to it today, but we can discuss those things. So I'd ask a motion to accept the agenda as presented to us.
Second.
Motion made and seconded. Any other discussion? All in favor?
Aye.
Opposed? Okay. We've taken care of that particular part. A legal report. I'd like to. Well, let's go first now. Let's take a look at the minutes for the meeting of January 2015. Given copies of those, Donna sent those out. Everybody had an opportunity to review them.
So moved.
Second.
All right, motion made and seconded. Any other discussion? All in favor signify by saying aye.
Aye.
All opposed? All right. Minutes are approved. Now it's time for the legal report. Good morning. How are you doing this morning?
Fine, sir. How are you?
I'm okay.
Good. I'll start with matter number one here, case number 2015-003181. This complaint was filed by a consumer who alleged that respondent removed certain stakes and placed new stakes where her neighbor told him to put them. The survey was not finished due to the disagreement between respondent and complainant, and no money was exchanged for the performance of the survey. Complainant states that respondent told her husband that they were, quote, short 23 by 100 feet. Respondent states in a sworn affidavit that he did not put stakes where her neighbor told him to put them, and that he did not finish a plat because he did not get paid, and he left the job due to complainant disagreeing with him regarding his findings of where the boundaries of her property lie. Respondent states that he does not have a contractual obligation to remove the stakes he placed while attempting to complete the survey, but that the complainant may remove them if she so chooses. There had been no discipline against this particular respondent in the past, and my recommendation is that we close this matter with no further action.
A point of clarity, Josh, it does indicate a significant number of prior complaints, but there has been no action on any of those complaints. Is that correct?
That's correct, sir. Did look at the history of those briefly for my own review, and some of them are pretty old, and the more recent ones, actually I think those grouped together were the result of the same complainant, which were all dismissed. And then the 2013 one listed there looked like it involved a different allegation, and it was closed with no action. So therefore, my recommendation is we close this one with no action, despite the number of older complaints.
I'll tell you, based on the information that's provided here, it really seems to be kind of boiled down to almost a civil action with a disagreement, he said, she said type thing, placing stakes, pulling stakes. Really nothing that I can see on the surface of it that has to do with the professional obligation based on the rules and regulations. Rather, it really boils down to probably a civil case, really.
Having heard what you said, Jay, and I agree with that, I'll make a motion that we concur with Mr. Kilgore's recommendation.
Motion's been made. Discussion? And all in favor of accepting the staff recommendation, say aye. Opposed? Okay. All right, Josh, that takes care of number one. Number two.
Number 2 is case number 2015-004581. This complaint was filed by a consumer concerning a boundary dispute. Respondent was retained by an abutting landowner to the complainant to mark boundaries for 200 acres he had acquired. Complainant alleges the boundaries are incorrect and that respondent failed to use deeds in constructing his survey. Complainant hired another surveyor who apparently disagreed with respondent's findings. This matter was heard in Claiborne County Chancery Court, and the boundary was set in favor of the respondent's survey. Therefore, my recommendation here is that we dismiss.
Yeah, and I think based on the information provided, it's kind of a surface issue here. There's really no complaint here to the survey itself. Rather, just looks like a respondent wasn't happy with the results of the original surveyor. If I understand it correctly, the original surveyor, the case went to court. The original surveyor's survey was held. I don't see any specific violation here that we can handle on this.
And again, Josh, I notice a lengthy list of complaint history, and I'm sure you reviewed that. No.
And all of them were priorly dismissed, so I don't even think that we can rightfully consider those. I mean, as they were dismissed, not just closed.
Well, as a source of fact, that's why I question.
Right.
Yes. Again, based on Jay's review, I agree with that, and I make a motion that we take Mr. Kilgore's recommendation to dismiss.
Okay.
Second that.
Second. Any further discussion? All in favor? Opposed? All right. Josh, number 3.
Mr. Chairman, if I may, before Josh goes into case number 3, I would like to recuse myself from this matter.
Okay, sir.
Case number 2015-005021. Complaint was established when it was brought to staff's attention that respondent had been operating a surveying office in Franklin, Tennessee, and sending out email solicitations that appear to indicate that he is a licensed surveyor in Tennessee when he has not yet passed the exam or obtained licensure with this board. There is no complaint history, but my recommendation is still to authorize a formal hearing with authority to settle via consent order for a civil penalty in the amount of $1,000 for violations of TCA 6218-101B and also 6218-120B and C, I believe.
Josh, real quick, again, this is just such a short narrative of the case here, and this, obviously this is all the information we have. Can you give me or expand a little bit on what information that we have in terms of proof that he of some sort? I assume that we have these emails that are.
Yes, the emails were sent to multiple recipients, just kind of like what I would refer to as an email blast.
Okay.
And it did look like he indicated in there, made representations that he was licensed and that he was open for business and was seeking, basically soliciting other surveying firms and other consumers within the state of Tennessee from his Franklin office there. I believe it's pretty cut and dry as far as.
As a part of the investigation of this, have we verified that in that office there is not a Tennessee registered surveyor full-time in that office? Not just individuals. That's what I'm asking. Have we verified that? Do we know that?
Yes, I believe there was some indication in there. There was not a further investigation into it, but due to the fact that it seems like a pretty cut and dry, unlicensed activity type issue, I feel confident that we have enough information to establish probable cause that,
Comments or questions, I'll make the motion to accept the recommendation from staff to authorize the formal hearing.
Second. Any other discussion? All right, all in favor?
Aye.
Aye. Okay.
last matter here, case number 2015-008141. Complaint was received from a consumer who received a letter from respondent after he had conducted a survey for an adjoining landowner, during which he found a major discrepancy in the deeds and what he saw on the ground. The result was a new boundary that would remove 5 acres from complainant's property. Respondent states he did his due diligence and researched all deeds to draw his conclusions in laying out and conducting the survey, and stated in his letter to complainant for her to call him should she have any questions. Respondent states that the complaint was the first time he has heard from the complainant. I didn't find any violations of the Surveying Act here. I mean, he did his due diligence to contact the complainant and advise her of the discrepancy. If she has an issue with it, I believe her best course of action would be to go through civil court, and that would involve her and the adjoining landowner. So therefore, my recommendation is to close.
Clearly, I mean, as written, the respondent did exactly what our statute asks us as professionals to do. So based on that, motion to go with Mr. Kilgore's recommendation to close it.
All right. Motion made and seconded. Any other discussion? All in favor?
Aye.
Aye, okay. Thank you very much for the report.
Good job.
The director's report.
It's my turn.
Turn, Ms. Donna.
We need to discuss the implementation of the new continuing ed rules. In the new continuing education rule 0820-04-.10 that took effect February 15th, 2015. Are the 30 hours and 2 hours ethics and SOP going to be due by December 31st, or will they be due by the next renewal period, December 2017?
Mr. Chair, if I may, knowing the history and the path that this particular change took, it was anticipated in my mind that it would have happened sometime last year, which could have made 2015 a cleaner window of time to deal with the changes. But since it did not happen until February the 15th, it's my opinion, and only my opinion, that I think that we should continue through the conclusion of 2015 under the same premise and direction that we've been going to close out this renewal at the end of this year. And I would think that it would be appropriate to start January 1 with the new scenario, because we're going biennial at that time for the 30 hours. And one point of clarity, the 2 hours of ethics or standards of practice, those are required, if I remember correctly, and please correct me if I'm wrong, to be 2 hours each year. In other words, 2 out of 15. So it would be 4 out of 30.
That was going to be my next question.
It would be 4 out of 30. That's my recollection, and I can certainly stand to be corrected. But I would like to make a recommendation. If we need to craft a policy or whatever it is we need to do, I'd like to see us do that so that we could put that on, whatever our decision is, whatever the board decides, put that on our website so that the registrants understand how Donna and the staff is going to administer when they turn in their PDHs and so forth. That's kind of my direction on it.
Okay.
Yeah, I tend to agree. I think because of the date and it, of course, the rules, the new rules didn't go through quite as quick as we thought, like you mentioned. I think we need to err on the side of caution and to the benefit of the. I would tend to agree that come January 1st, 2016 is when the.
Well, I would just want to ask Josh also if there's any problem from the legal side of us actually doing that with the chapter becoming effective February 15th and us actually having a little bit of delay because, theoretically speaking, I guess in a way, all registrants that were registered as surveyors prior to February 15th of this year were already working under accumulating their hours. For example, if an individual that was duly licensed on January the 1st of 2015, if on January the 10th of 2015 he went and got his continuing education to meet the prior continuing education chapter, then I find it problematic for us to deny or ask him to do something new during the course of the year because he already did what he thought he was supposed to do. That'd just be an example.
I don't think that there's a problem with that because the way I look at it is I don't know that you can make the rule, retroactive, and if they've already met the requirements they were operating under as of January 2015. I logic that the board's going with there.
Those were our standards until February came.
Right.
So.
Right. I don't know if that's true for anyone that kind of came in after the effective date.
Well, let me say this. After the effective date, you would have two types of individuals. You would have one that was having to do something to renew their license because they were delinquent for some reason. But we're in the middle of a renewal period, and that's probably very remote, and Donna can address that. And then the second one would be anyone that was newly licensed basically has a free year to start with. So we don't have any issue with the new licensees. So it's basically the existing licensees effective January 1 of how we assist in addressing them. And Jay very aptly said it, it wouldn't be hardly fair to, put something new on.
I think I agree with that.
So I guess the next question is, do we need to have some type of motion for that, or to craft something to put onto the website? I think we should put something on the website so that the registrants understand that, everything's the way that it is basically until January 1, and then you will be held to the standard that has just been, enacted February 15th.
I think that's enough as long as notification is made available to them through the website. I think is adequate. And you really don't even need it on the website after that, to be honest with you. But I do think there, because Donna, you'll be getting the phone calls.
I'll tell you what, I'm getting phone calls. 65. Go ahead and go into effect now, or do they have to? Can they go ahead and request that they get that hardship?
Well,
The 65-year-olds.
Can we make sure we kill this one first, the one we're talking about, and then we'll shift gears?
Yeah.
Just so we don't get
I just wanna
them
bring it up
mixed
before I
up.
forgot.
So we don't get them mixed up, and
Right.
then we didn't answer all the questions in order, if that's okay.
It's fine with me.
Well, I think, I don't know, I'll entertain a motion then to draft a statement from the board that goes in on our website, just explaining what the registrant can do from now until the end of the year and starting.
I'll make that motion.
All right, motion is made. Second. Any other discussion on it? All right, all in favor?
Aye.
Aye, okay. We'll do that. Now, that's the senior citizens now?
Yeah.
Okay.
Because I've been getting, most of my calls have been about that. And they want to go ahead and request the hardship. So I told them I'd let them know something for sure, what they would need to do after this meeting. Can they go ahead and request it? I've made up a form that I can send them, they can fill out and send back to me, and I can do whatever I gotta do. But they have to have 4 hours of continuous, of ethics and standards of practice, right?
After
the first.
this renewal, yes.
Right,
Yes.
okay.
Well, Jay and Galen, in the spirit of fairness, do we want to kind of wear the same set of shoes for those folks too?
I think so. I think number one, I think it's important that we're consistent.
Mhm.
I think we would send the wrong message if we apple and orange this thing. So I think consistency is important. Obviously, even though this, the advantage may be to the surveyor to apply the 65 and older right now, but I don't think that.
Okay, with that being said, well, we'll get to that in a minute. There's, I got a couple of continuing education courses for you to review. One's from Kenneth Beckwith and a couple from Daryl Isbell. They're both Tennessee residents. And they took out-of-state courses that weren't.
Well, I'd like to speak on this a little bit. Yeah, obviously I'm from the Memphis area. I am aware of both these surveyors. I don't know them personally well, but I am aware of them. But not that changes anything. I also have attended both these conferences, both the Arkansas and the Mississippi, at different times. There is a lot of overlapping value here to these courses that they took. Now, I do, when I look at them individually, I do have question with a few of them. To be specific, standards of practice for surveying in Mississippi.
Right.
I don't know that I would feel consciously good to give credit for that applying here in Tennessee. I'm sure
Right.
there's a lot of value to that from the Mississippi surveyor. I'm one of them that's taken that course. But what I would suggest to, and I think we've done this in the past, is because they're itemized with the hours, I think we should go through them individually, and if we so choose, tally up those, and if there's any that we don't approve, obviously exclude. So Donna, if you're looking for are you looking for a total number of hours that we may approve right here of the
No,
list?
I just want which ones y'all will approve. I can total up the hours after
Sure.
they're
Yeah,
approved.
yeah.
So it would be just simple enough for us to pick on the ones we're not going to approve?
I think
Yay
that
or
would be
nay,
quicker.
yeah.
That'd be
Yeah.
a little quicker.
And if we can just address these, the first just start with Daryl Isbell, is that correct? Mm-hmm. If we can just start with his Mississippi hours that he submitted. I'll just speak up for the ones that I would choose to exclude here would be the MAPS General Membership Meeting with one practice for surveying in Mississippi for 1 hour.
Do you question any merit for the state of Tennessee in surveying sectionalized lands?
I do, yes, because Memphis has sectionalized lands.
Okay.
There is a strip along the southern border of the state that has some sectionalized lands, and I did question that when I saw that.
So just two courses, number 8 and
It actually has that on there twice, because this is the 14 meeting and the 15 meeting.
Right.
So we would remove that from both meetings. Would that be correct, Jay, in what you're
Yeah,
saying?
at this moment, I'm only addressing the top section that he applied for from the maps, for, the first year, I guess it is, the 2014 conference, convention. On the 2015 convention, again, the same two, the MAPS General Membership Meeting and the Standards of Practice, I would choose to exclude. I do have a question, however. I'm not clear or understand what the one that's entitled to accept or not accept parts 1, 2, and 3.
That's all it said.
I'm not, are y'all?
I don't know what that is.
Are y'all familiar with that, or what that would be, or?
No.
Jimmy, you're a Mississippi surveyor, does that mean anything to you?
I was at I attended the 2014 conference last year, and I'm not sure what that. Not sure what that is.
I think I would probably choose to exclude that as well, only because there's just not enough information there. Now, if he can follow up with additional information to explain that, Perhaps at the next meeting, I would feel differently, but at this time, I don't know what that is.
All it says is to accept or not to accept part 1, to accept or not to accept part 2, not to accept part 3.
Does he have a speaker by that?
Dennis Mullen.
Oh, that was a seminar. I remember seeing that, reading the, I remember reading that was to accept or not accept this question. It had to do something with evaluating evidence. It looked like it was a good seminar, but I'd have to go back and look at my notes and see what it says.
I don't think it's inappropriate for what Jay said to ask him to provide a little bit more data.
I mean, I give him the benefit of the doubt.
You
I don't
know,
want to completely exclude it, but I think if he could.
Yeah.
provide a
I'm
little
sure
more
there's
data,
some
the
type of
values to it.
syllabus, I'm sure there's some type of general
Sure.
syllabus for that.
Dennis Mullen, is he with the BLM?
Yeah, I think he's with Cornerstone Seminars or something.
Yeah.
I think it probably would be a good seminar, but I don't recall the information off the top of my head.
Everything, all the others are accepted.
The others are accepted, excluding the MAPS general membership
Right.
meeting and the standards of practice.
Right.
And the only one I would question would be the to accept or not
That
accept.
would be 4 hours then,
Yeah, we'd be taking 4 hours away.
2 on each year, 14 and
Right.
2 on 15.
Right. And withholding approval on the 5.5 until we have some kind of syllabus.
All right, the second applicant here, Mr. Beckwith, attended the Arkansas Society of Professional Surveyors. Again, same situation here. The only ones that I may choose to exclude would be the annual membership meeting. But I would like to bring it up for conversation, the vendor showcase. There is value to the vendor showcase, absolutely. Certainly there's a vendor showcase at the Tennessee one every year, and there's certainly value to it. But I'd like to hear some other opinions on that one, but.
Well, again, we know what that means to us here
Yes.
in Tennessee. It may not mean the same thing in Arkansas. I would tend to lean to want more data about that one.
Okay.
And I agree with the other one that you want to eliminate.
Of them that we would exclude the vendor showcase and the annual membership. Not speaking for y'all, but.
You had more than enough hours there anyway, so you had like 18 hours. So if those two are excluded, it should not be an issue.
The only thing carry over, and so that's excluding that.
Okay, then I have a couple of exemptions, age exemptions for y'all to review, but since we're gonna wait till the 1st of January, I don't know if we should even consider them.
Now, are these exemptions relative to the new?
Yes.
Okay.
They went ahead and sent these in, so. They didn't call, they just sent them in.
I'm following the discussion, this is new to me too, so I'm.
But should we go ahead and do it, or should we wait and do it when we do everybody else's?
Well, my question is, was there hardship application strictly on age?
Yes. These two were.
Prior, basically stipulated physical disability, illness, or other extenuating circumstances as reviewed and approved by the board. Documentation submitted to the board. You know, we had a gentleman, I think in Chattanooga. I would think that, I mean, that's what the prior says.
And one of them has already turned in 2 hours of ethics
Yeah, but
and standard.
have education for 2016.
I'm just trying to follow it because we're going to have a lot of applications and you guys don't meet again for another 4 months.
Based on what we had previously said, if I understood correctly, we were not going to approve any of them, based on what we previously said. Now, correct me if I did not understand.
That was the intention and hopefully the understanding of what my that not only the continuing education rule, all the rule for that matter,
Right.
really don't apply until the first of the. What's the difference if it hadn't been approved February 15th or December 15th? Yeah, but what's the difference? I mean, you have to give the surveyor the benefit of the doubt to allow them the time to acquire it. And I think just the right thing to do is to put it in effect the first of 16 to give them the benefit.
Benefit them, wouldn't it benefit them for the
Well,
hardship to
That's why I
implement
said
it
there's going to
now?
be some kickback on the 65, and that's why I just maintain that we need to be consistent here. You know, I don't want to give the impression is that, all right, we're gonna make it 16 for the continuing education benefit, but the 65-year-old, that's effective right now. That's apples and oranges. I'd like to keep it consistent and straightforward.
Your opinion about that, because the law is already in place.
That's right. Yeah.
Right. The rules are in place.
I have to agree with Jay. I think we need to be consistent, but since that law is in place concerning this particular thing, I don't know if we had anything ever come up concerning the age. This is a new thing that we could put in here. So.
And if I've met that requirement, I've met what your rules say.
Don't have the new rule on our iPad that I can find. I think in the opening paragraph in hardships, I don't happen to have mine in my hand, but the opening paragraph in hardships gives the board some discretion.
This is not the updated version, because on the bottom
Right.
it says revised 1999.
Do you have it, Jay?
So-
Look in yours.
Dennis probably just didn't replace it.
I think I laid it
with the
down
new
at the
one
office
from
before I came.
Oh.
Let me see if it's in this stuff right.
From the Secretary of State. He didn't print out the current one from the Secretary of State, so I
Right.
apologize. In fact, I don't think we could deny a licensee the ability advantage of something that's in the rule.
I can review it if we take a break, or if,
Be a good idea.
you know, I can get back to you later on in the meeting if you'd like.
As I recall, when we might, this is just off the top of my head, and please do that, Josh. Opening paragraph that goes with hardship, and the dialogue in that paragraph basically says that the registrant needs to provide information to the board, but it's on the board's discretion that everything's in order.
It does say may exempt.
Yes.
Notwithstanding any other provision of this chapter to the contrary, the board may exempt a registrant from complying with all or part.
I think it gives us some discretion. And I think we spoke to our discretion in what we spoke to earlier. That's my thought.
It does say may. I just don't know. Kind of going back to what Jay said, he said he didn't want to do apples and oranges. I'm not sure, if you have discretion, then you could take it on a more case-by-case basis. And so you're really not stepping outside of the scope of the rule if the board chose to treat the people who are applying under the age exemption as opposed to the continuing education issue.
Let's revisit that just a minute then, if we can. If, based on what Josh has just said, then if John Doe surveyor physically applies and meets the criteria, then we could act on that because that's what the current law is, or the staff could act on it. If in that spirit, then we would not want to stipulate anything relative to that hardship on the website. We would just stipulate about what we said about. So, in other words, what I'm saying is that way we're not necessarily ignoring those folks, but the onus of them applying or doing the right thing to get to that point is totally up to them, if I hear what Josh is saying. And then we react on that because they did do the right thing.
That's a good way to go about it.
Would that be fair? So
That's
if
the
we
right
can
thing to
kind of
do.
rescind something that we previously did, Donna, let's don't mention the hardship, the 65 and older on the website, other than just what the statute said, or the chapter says. Is that fair?
That's the right thing to do.
I think it speaks for itself. So, and it wasn't effective until February 2015. So,
Right.
not to cut you off, I'm just saying the applicants prior, as you stated previously, they were under different, they had a different standard to meet, and now we're talking about people after the February date, and we're also talking about an age exemption, which they've, I think, already met in this case, and the board does have discretion about whether or not to waive the rest of the remaining 2 hours in these cases. That's completely up to the board. I think the way that the way that the rule is written.
Well, I think it's the waiving the rest of the.
So I guess, Donna, we need to go back at some point then and revisit these two folks. Approve them, or were you only asking us to discuss them?
I want you to approve or deny.
I think, and I think that. I hold it up if they've met this requirement and it's in.
Again, that won't happen until after December 31st.
Not a class or anything available.
Discuss that maybe.
Well, one of
If
them,
they are, all right, let's discuss
one
that.
of them
Let's-
has
let's
turned
rethink about
in
that.
2 hours of ethics already.
Yeah.
I think these classes are pretty readily available.
Because the renewal cycle is going to open up here first, very soon. And one of the things that we should probably be, I'm going to tell you as board members that
Edison die?
No, not Edison.
No,
Oh,
not
Edison hadn't died?
This is
Okay.
our
No,
licensing program.
Oh, okay.
This is going to be our licensing program. We have a very old system called RBS, and it's been in effect since the. Good job, but it's very old and unwieldy. We're getting a new one. That means for a little while we're going to have to shut the old system down in order for. That's approximately when the renewal cycle is gonna be opening up.
Let's talk about the two that Donna has then. She has one that is applied with the proper application, and you verified that they meet that criteria.
He's got 2 hours.
Now remember, 65 is not the only criteria.
Right.
They gotta have
Yeah,
25 years
active registration.
active registration.
Right.
You know, and it'd be nice if that was clean registration, but we didn't say that, but anyway. So when they do that, then you could qualify them as staff that they met that.
Right.
But you would also, in my mind, need to notify them if they have not submitted 2
Right.
hours of either ethics or standards, that prior to December 31st, 2015, they would be required to submit 2 hours of either ethics or standards.
Right. And we would do that.
Okay. As long as
Just
you
like
do.
we would do if they sent their money in and didn't send all their continuing education, we let them know too, so.
As long as I think, in my mind, as long as staff is doing that, I think that we're fine. You know, that way it doesn't put the onus on us to vote on it or any of that kind
No,
of
the
stuff.
only reason I bring it to them is if it's not pre-approved.
Right.
Board needs to vote on every single one of these things.
Yeah.
That's why we put this in place. Cover those situations.
Yeah.
So are we good then with that then?
Yeah. These two are-
Just as long as they, you know, whenever they send in, just as long as they know that, hey, 4:15, you gotta have 2 hours.
So this man needs only 2 more hours in standards of practice. Got 2 hours of ethics. It's
or.
two-
It's either
oh,
or.
Either or. I
It's
thought it
either
was
or. It's either
both.
ethics or standards.
Oh, okay.
Okay, the hope in that was that 1 year of the biennial renewal, you would get 2 hours in ethics, and the next year you get 2 hours in standards.
Okay,
That's the
gotcha.
hope.
Okay.
That way they get a broad base.
All right, then, are we done with that? Number 4, we need to vote on who to send to the NCAAS annual meeting in Williamsburg.
Make a motion that Galen and Jay go. Unless Miss Sue would like to go.
Second it.
I plan on attending either way.
Okay, and I do so. Motion is on the floor.
Second?
Mr. Kaufman and I, yours truly. Second? I guess we did.
Second.
Is there other discussion? Okay, all in favor?
Aye.
I'd say aye.
I'm done,
That's quick.
wasn't it?
Okay, let's see, what's next on our agenda?
Again. We have no legislation, however, the House Bill 759, which is related to drones, didn't get out of subcommittee.
Okay.
That's it.
For that, I guess there's more work to be done on that one, isn't there? What? Even though we've been going 45 minutes, one never knows what one. Let's take a few-minute break here, and then we'll reconvene and going to take up some issues that have been, those that have requested meetings with the board. And the first one that I have on docket here right now is Mr. Adam Leftwich. Adam, if you would come up, feel free to have a seat and speak loudly into the microphone. And what I have here, I have a letter from you. Said, this letter is to inform you that I would like to request a meeting with the board in order to discuss the denial of my application for licensure in the state of Tennessee. The grounds for my denial was an incomplete plat submission due to the plat not being properly signed. Please believe that the lack of signature was an administrative error on my part and not indicative of the care and quality that I apply to my boundary surveying practice. If it suits the board, I'd like to have the opportunity to provide you with signed plats and address any other questions or comments that we might have during. Mr. Leftwich, please state your name.
My name is Adam Leftwich.
Okay, and you're on the docket here and on the floor, so state what you'd like to talk about.
I would simply like to reapply. Ms. Mulder had informed me after the denial of my license. Guys, so here I am.
As we reviewed your previous application, and I'm going by recollection, all we had, I think everything was probably in order, maybe with the exception of that particular thing. I presume that you have plats that have been redone or other plats that you'd like to present to the board.
I did not bring any today. Ms. Mulder informed me that I would need to do that at the next application.
This exam or the TS?
Mr. Leffridge, we don't want you to feel like that we're picking on you, but, 0820-1-02 under applications specifically says the plats must meet our standards. And obviously, the omission of a signature is one of the standards. It has to be on there, so we try to be very thorough when we review the plats and also very fair across the board, particularly when it's relative to standards. And you kind of got caught, and it's sorry about that, but I would say that you just need to get Donna the appropriate information for the next board meeting, which I think is July 31st, and that would put you in line. Thing is in order at that time and approved, you'd put you in line to take the October examination.
Does he need to reapply, or we use the same application?
What's the timing on this application? Is this the first application he's sent?
I did, yes ma'am.
I think our statute says that if you're denied, you have to reapply by statute. No, sir. No, sir, that will still be in the file.
Application and the fee and,
Yes.
Plus the application, and then that should take. The questions that you have of us, do we have anything to ask of Adam? Okay.
Thank you for
Thank
coming.
you. Oh, yeah, that's the one I wanted to look at, so.
I got his file too.
Next, one requesting to meet with us, Mr. Justin Parrish. Justin, sitting in front of the microphone over here. And Justin, in your letter, you state that you'd like to schedule a meeting with the board as soon as possible. My application was denied in lieu of my experience, not immediately following the passing of the fundamental of surveying exam. And I've written in our records here that we needed 2 years post LSIT passing of the exam, so that's what we were looking for, was that kind of experience. Open to you. Now, tell us a little bit about what you have done or added to, or what have you.
Yeah, I was just,
Would you state your name for us, please?
my name's Justin Parrish.
Okay.
Nice to meet all y'all here. Hate it. Trying to wrinkle out some things anyway, iron out a few things. Working for surveying services in mid-November of 2012. Half years of experience up until this point. Working with Miss Avers and Miss Mulder, and law had been passed saying that you have to have your experience post. Experience that I obtained before passing, the law being passed, is there, if, you know, y'all are the experience that I obtained before the law was ever passed, whether you might be able to give me law was ever passed, and basically it was under an old rule. You know, I have a half of experience under the old law, as far as it going into effect, as passed the exam in July of 2014, because I think the law was passed in April of 2014. So I got a gap there in my experience between the passing of the law and me passing the possibly give me credit for the experience I did obtain before. Possibly the experience that I obtained after passing the fundamentals exam, which would bring it up to about, rather than 2 years and 3 months, rather than 2.5 years altogether. There's a little gap in between the passing of the bill and the
Fundamentals in
July
July of
2014.
last year.
Yes, sir.
That would mean that the earliest that, under current statutes, the earliest that you could take that would be in 17. Okay.
Law was ever passed or went into effect.
I'm reviewing your application as you speak, Mr. Parrish, and I note in your application that you went to Mississippi State University and you got a BS degree in agricultural engineering with a concentration in land surveying, and you graduated in 2011. By our prior licensing scenario, that would have qualified you probably under a Category A scenario, and you would have been able to take your fundamentals examination after your graduation. Actually, in the final quarter or semester, whichever Mississippi State does, that you were in school, you would have been able to take your FS at that time. I would see it as your choice to have waited to take the FS when you did. So I guess from the scenario you presented, I feel like that you had opportunity from somewhere, well, probably the April exam of 11, I felt like you had opportunity from that point in time up to when you actually took the examination in July of 2014. You had that window of opportunity to have taken the examination, which would have also triggered your 2 years' experience from the point that you passed the examination. Clearly, you stepped up to the plate, took the exam, passed the exam, which we're very grateful for that, and we're very grateful that you're desiring to be a surveyor in the state of Tennessee. But I guess what I'm saying is you have had opportunity, and I don't feel appropriate at this moment of going back and reaching back with the current law and so forth, and having seen what I said and trying to assist you to advance you to taking an examination quicker because of what I just said.
I realized that I had opportunity, but I guess I never, at those times, I never read anything in the law saying that it had to be post fundamentals. Graduated, it was nothing to really kind of motivate me to take it if I hadn't even started getting my experience yet. What was the point in taking the fundamentals test yet if I haven't even started?
I understand where you're coming from, but it says in the prior law, and the new law says the same thing the prior law says, basically about a Category A, even though it's no longer called that. It says passes the 8-hour fundamentals and acknowledges as a PLSIT, and then submits evidence that person has obtained a total of 2 years of progressive experience on survey projects working under a licensed land surveyor. So that's what the prior one said in 2011. That's exactly what it said. So, I don't note any significant difference between what it said in 11 and what it says today for that scenario of your degree and so forth. So, again, in my mind.
What does it say? Sorry.
No, sir, go ahead.
I think y'all actually accepted my application under Category B. Is there a copy of the old laws in front of me? What does it say?
Category B was an additional of 24 hours to your. It still reads exactly the same. In other words, you pass your FS examination, 2 years experience, then you take the PSTS with, of course, the board approval. I think that I'm seeing two things in your scenario. One was a possible delay on your part for whatever reason, and because of that delay, it rolled you into a cleaner definition under the new law, and because of the timing you actually passed it, it put you under the new law, and basically, as a board, in my opinion, our hands are then tied. If you had, for give you an example, if you had passed the FS in, let's say, February of 14 versus July of 14, you would have been prior to the new law coming in. And then the boards previous had looked at experience when it was experience, period, not at a timeline that was triggered by passing an examination.
Yeah, I did take it in February. But, so it doesn't have anything to do with start date of even is.
So basically, under the law that you're operating under, you would have your experience in July of 2016, your 2 years after passing your exam, which would STS in October of 16. Actually, yeah, October 16, because that'll be October 16 with the last paper and pencil PS exam, because it converts to CBT after that.
I started working in 2012 thinking hey, I'd be taking it. But since then, the laws have changed, and there's no way that time frame that I was working, and the laws didn't specifically say that.
I would be, first off, I want to tell you, I'm very sympathetic to your cause, because, we always want to encourage anyone that's in the application process to continue and get their license and be a productive member of our profession in the state of Tennessee. Clearly, there's no question about that. But you have just, in my mind, you've seemed to be kind of got caught in a catch-22 with the timing of everything. Clearly, I think this board would have been very sympathetic to your prior experience had you passed the FS examination prior to the new law. That's kind of where I'm at, and I'm going to hush and let Jay and Galen talk.
Well, I have to agree with Tim, because I think, unfortunately, we're bound by the law, and the law has stated what Tim has given to you. And very much your willingness to come up here before us, but there again, our hands are tied by what the law.
Yeah, I agree, Mr. Parrish. First of all, I want to give you all the credit for coming here and explaining your case. That's a big step forward. Professionalism itself. And I do expect that in the future you will become a professional surveyor. I have full confidence in you. I'm certainly familiar with the company, Surveying Services. I know Bruce well. A good friend of mine has been involved in the professional society for years, and he only hires and employs quality people, much like yourself. So first of all, number one, I want to feel for you. I sympathize with you. Unfortunately, it is kind of caught in the transition of old law and new law, and there is a select group of personnel that will be much opportunity to get their licensure. But it is clear the law is what the law is, and our hands are tied in this case, and for that. Can't justifiably bend the laws. That's not what I can do, and I just don't see where we can.
Like to add to us?
Time I got under the old law, just being time that I spent working for Bruce, that I was expecting to be putting to my 2 years experience.
Let me say this, and I say this to licensees, and I know you're not one yet, but licensed surveyor is a right. And with all rights, it has privileges. And with privileges, there are also responsibilities. And part of the responsibilities are what is in our statute and our rules. And so, I feel bad for you clearly, but I also want to say to you that, it was important in 2011 that you understand what the licensing law was asking you to do in order for you to progress post-graduation into becoming a licensed surveyor. And whether that was, your misunderstanding or your employer's direction that may be incorrect, or however that got to that point, that, in my mind, is why you're here today. So, I feel like that there was opportunity, and that opportunity was unfortunately was missed. Or wouldn't be here today, and you would be maybe down in Murfreesboro taking an examination. I apologize on that part, but I certainly echo the sentiments of Jay and Galen as far as we appreciate you. We look forward to you becoming a licensee and being a valuable member of the profession. And we're sorry that I know you'll leave here today feeling as though you're frustrated and that we delayed you. And I'm sorry for that.
To continue in education, that you kind of do something along the same lines for my situation, but
I don't know anything that we can do to accommodate that. I really don't.
Under the rule, there was discretion built in with the word may, and I don't see any discretion under the statute. Written, so I have to agree with the board's position here.
Wish it were. I wish that we could do that. But we can't break the law once it's in place. It's our responsibility to uphold it. And so we just have to do that.
all that was in place at the time that I was working. Can you withheld that law, and then as the time it goes in, withheld the new law?
I think Mr. Lingerfeld has aptly explained that previous statute said and what our current statute said, and we just can't say this, that another year and a half, and you'll be even better than what you already are. Couldn't be with the firm that you are, and so your willingness to come up here and plead your case, but I just don't see that we can do that. So, or that you're caught in between these things, but
Started the land surveyor's license. A lot of guys kind of got grandfathered in, didn't they? They were already practicing. You know, kind of transitional type things. It kind of smoothed out. There's no.
Time today, Mr. Parrish.
Johnson, Mr. Sides, please come up and take a seat where you can be talking into the mic there, if you would.
I've got a small package here. Sure.
Sure.
One short.
He had his book before I put it.
I'm Kurt Johnson, owner of Johnson Associates land surveying firm in C. The packet I've handed out is concerning Mr. Jared Sides. He is applying for application under the 10-year rule. In the packet, it's a brief packet. Approximately 10 years ago, Mr. Sides received a felony conviction, which he can explain to you is a bogus conviction, but I know that's not for us to judge. Also in the packet is a court order restoring Mr. Sides' rights. restoring all of his rights. However, it did not expunge the felony conviction. So he still has it on his record. He has all his rights. The other letter is a letter from Congressman Scott Desjarlais, and the reason that's in there is just sort of as a character witness. His stepson worked for Johnson and Associates for a period of time until I think it was of December 2014 when he went to work for the railroad for CSX. That's what that letter's concerning. Mr. Sides has worked for me for about 13 years and has been an exceptional employee. He's a tremendous land surveyor. He's a credit to the profession. And I say that with as much conviction as I can muster. He would be a tremendous asset to the surveying profession. We wanted to just make a presentation to the board, one, to explain the conviction, the felony conviction, and two, so you could put a face with the application in making your decision to accept or not accept his application. That's all I have. I'll let Mr. Sides brief presentation. If you have any questions from me or Mr. Sides, please feel free to ask.
Hello, I'm Jared Sides, and I'm the applicant here. Made a horrible decision about 10 years ago, and I paid for it ever since. I've been adamantly trying to remove this or alleviate the issue, as you can see with all else that I've been through. I love surveying. That's basically why I got in this profession. I did a brief stint in the military as a geodetic surveyor there. Got out, Mr. Johnson here, he hired me and gave me a shot. I was young. As you can see, I made some bad decisions in my life. But after that moment, I regret it, but I don't regret it because it was a turning point in my life to where I did learn something. Nobody to blame for this but myself, and I've always taken full responsibility for whatever I've done. Like Kurt said, I just wanted to be here to give a face with the application and let y'all address me or ask any questions of me.
I appreciate you coming before us and having taken a look at what Mr. Johnson has given us here and the court order. That record, I guess, has been expunged from that. Does that appear that way, Josh? Have you taken a look at that?
No, I think based on, I think based on what they just stated and reading the order, I don't think that the felony has been expunged, but his rights have been restored. And I think that's why he's here today, just stating, if I understand correctly, just stating that the felony, while not expunged, you have had your rights as a citizen restored. Okay.
What would, if it were expunged, that mean that it's no longer of record and
Right.
and erased? So
Right.
what does that do to us as a board?
I was looking at the rules because I don't see it in the law, so I was turning to that right now.
Okay.
No, the only section that I see, 6218.116, denial, suspension, or revocation of certificate. And it does say very clearly that we may refuse. The board may refuse to issue a certificate of registration, may revoke, suspend, or refuse a new certificate of registration. A couple of categories, letter E, any conviction in a court of competent jurisdiction of a felony. But I do want to make sure and emphasize, if I hadn't already made it, that it does say may. It doesn't say shall or will. It does say may, which obviously gives the board some discretion. I would like to give Mr. Sides full credit, and Mr. Johnson as well, for coming forward and not trying to skirt the system by any means, and certainly taking the initiative to not let this stop you from applying. I give you full credit for that. I do have a question here. I haven't seen the applications that are coming through today. Am I under the correct assumption, Mr. Sides, that you have made application and submitted it, or?
It's for FS, and it's been submitted.
Oh, it's for, okay,
For us
so you
to
have,
review
okay.
today, yes.
Okay, good, that's perfect.
To expand on that a little bit, you know, I've been in the profession for a long time, 20-something years. And I realize the importance of getting good quality, ethical surveyors in the profession. You know, I know that this is what we're looking for as a profession, because this only grows our profession. Mr. Sides fits that picture perfectly. He's very conscientious, does an excellent job. He is chief of my survey parties. I can, relinquish full responsibility to him, and he carries out all his duties flawlessly. Not to say he doesn't make mistakes. We all make mistakes. But he is, in my opinion, he is the type of person this profession is looking for.
Well, all I can tell you is that we have those applications and we're going to review them, and everything else looks good in there. We will discuss this among the board here, and I don't know that we will make it.
I'd like to,
Drive back to,
not to interrupt you, Ms. Nicole, and I don't. Before we get to that step that you're requesting.
Well, I was just checking in the rules, and I don't think there's anything that goes against what Mr. Kaufman was just referring to. I mean, you do have the discretion there built into the statute, so.
Have some latitude there.
Right. I mean, it's in your hands, basically. And
Okay.
so you can take into consideration the court order. While not expunged from his record, does weigh, I mean, yeah, it reinstates his rights, and that obviously weighs favorably for him. And he has appeared, taking the time to try to do everything the right way. So, I mean, I think it's just back in your court as far as just review the application as you would any other application, and
And no disrespect to Nicole, but honestly, I think the correct thing to do here with an application, I do understand they're here, and I understand that we're taking their time. They're process that we do with all the others. And no disrespect to y'all or what.
That's the way we would want it.
I think just in the
that's
process of
fine.
keeping it the way business works, we need to just keep it the way business works.
We, just wanted to make a presentation to the board, and if you had any questions concerning the conviction, he'd be glad to tell his story. I don't know if you want to hear it or not, but I personally wanted to vouch for his character and state that he would be an asset.
Well, again, as Jay said, we admire y'all for coming. We appreciate you. Typically, when we use the particular statute that Jay referred to, it's more applied to an existing licensee, even though it does include someone working towards licensure. So, I would say to you, as a caution, and it's not something I'm sure you have. Is approved and you're able to move forward through licensure. Unfortunately, this is a small dark cloud that no matter where you go is going to follow you around because of just the way that it is. Okay, but you've already indicated, that it's helped you right the ship, and I think that's wonderful. I think it's wonderful, but I just wanted to throw that out as a caution because, you will have something, let's say, in your record with the board if you're successful in becoming licensed, that down the road if something else unfortunate happened that would not work in your favor. Yes, sir. So I mean, it's not something I don't think you don't know. But again, I appreciate you coming, and as Jay said, all due consideration. Thank you all very much for coming.
Thank you. Thanks for being here with us. Our next item on the agenda is to new, do what?
Laws and rules.
All right, laws and rules, disciplinary action exam.
Yes, I'll be discussing that. I think at the last meeting, which was my first meeting, so I apologize, I was kind of a little bit flat-footed there. I do think that in furtherance of discipline pursuant to a consent order, that the board does have authority to do the exam that they wanted to do, that y'all wanted to do. I had a little bit of concern about how it was drafted, just how it came about, because I just always have, a fear and want to caution about, violations of the Open Meetings Act and the Sunshine Law, because I don't know where this was developed or where it came from, and I'm not sure that it was done in an open, public way. But the board can still correct that, by moving forward, and any deficiency with that, we could, certainly have a meeting where the board makes a motion to approve the exam as written, what have you. I think the board charged me with the main question of if y'all have the authority to do it, and I think that pursuant to a consent order, you do. Don't think it could be brought forward at any kind of, pursuant to any kind of ruling after a formal hearing or anything like that. But I wouldn't expect that if a matter goes all the way to a formal hearing, I don't think that the exam is going to be the main concern of the board. I think at that point we're looking at civil penalty all the way up to the revocation, depending on how severe the violation is. I don't think that we have very many complaints that rise to that level in this particular board. So, I do understand what the board's trying to do, and I do think that they can accomplish that through various ways. I don't think that the exam can stay confidential or out of the public record, just as a practical matter, because of the way that it will have to be administered. I think that once a registrant licensee comes and takes it, that it's going to be public record, because it's going to be filed with the board office, and therefore there's not really anything we can do at that point to keep it confidential, just because of the way that the Open Records Act is written. It's definitely not going to fall under attorney work product or any of those things. I mean, I don't know. It may start out that way in preparation of litigation or in anticipation of litigation. You could make a stretch there, but I'm not really sure that that's going to hold up for very long, especially after it gets out there and people start taking it. Then it's going to be filed in their file. I mean, we could if the board wishes to do, I think I sought some guidance on this from the A&E board attorney, and I think that she advised that A&E does theirs because they do something very similar to this. I think that theirs is more like they get the respondent to sign a consent order wherein they say, I agree to take this exam and submit it back to the board office. But I think that's actually sent out with the consent order, or sent out in correspondence to the licensees, and they just take it at home, but they still have to, it serves the purpose of them reviewing the rules and the laws, which I believe that this is what the board's main concern is. And it would force them, I looked at the questions here, and I didn't have an answer key, so I admit that I didn't go through and try to answer or figure out the correct one for each question, but I did look at it, and it's certainly something that I would even have to look up. So I know that the licensees most likely, I'm not a surveyor, but I'm sure that they'll have to refer to the law and the rules to obtain the correct answer. So I do think that it could serve the board's purpose, as discipline and to help as a refresher for the rules and laws by sending it out, even if they didn't come here and have the exam proctored by staff or anything like that. Because even if we do that route, I think it's still going to be subject to being released. And after a fair number of people take it, then there's nothing stopping it from being out there. I mean, it's just like any other school test. I mean, if it's out there, it's going to be out there. But I do think that it would serve the board's purpose as far as refreshing licensees' memories and giving them, familiarizing themselves with the laws and rules that govern their profession. So, I certainly agree with the board's position on that. I just don't know how it's going to be administered practically. I mean, if it's pursuant to a consent order and they agree to it, then we could mail it out and say they have to complete it within a certain number of days and send it back to the office, and it'll be reviewed at that point. But that's just my suggestion.
So if I understand you correctly, to kind of summarize all that together, you're saying you don't see anything that obstructs us from offering this disciplinary exam, number one. Okay, so the exam can't way that we could ensure the confidentiality of the exam because of public records and because it's internally administered.
Right.
It's open to the open records. I completely understand that.
Okay, now let me ask this question. All of us take and is going to be given tomorrow in Murfreesboro. How is it confidential?
It's confidential because that's with a third party, and they're contracted to proctor and administer and develop that exam. And this would be an internal thing. At least that was the way I put it in my mind, because the alternative to that would take approval from the department, and it would have to go. If you wanted this to be contracted out and given, that's a different animal there. And I mean, it would have to go through departmental approval, and they'd have to look at the budget and, go through all those RFP.
Let me expand that just a little bit. What if in the consent order it said that John Public, who the consent order goes to, is required to take laws and rules examination, and it will be administered at the same time as the Tennessee specific examination?
I can't speak
Wait a
for
minute,
you.
wait a minute. No, he just said that Peter, who administers the Tennessee state specific examination, is a third party.
Right, but we have a contract with him to do that specific
Okay,
examination.
if his contract was amended,
No.
then he would be a third party. Is that not correct?
It would, but we'd have to get approval to do that. We can't just tag on another exam.
There's a process to get to where we're going. I'm just asking the question. I'm trying to
Right. I mean,
resolve this in my mind to try to
Ultimately-
not circumvent what you're doing, but just try to look at other potential options.
yes, I mean, I think that could be an option, but I just going to take a lot longer to implement, and I don't even know if it will ever, because I can't speak for the department, so I don't know if it'll ever get implemented the way that the board wants to. So I was trying to go with the most direct, easiest route to administer under the board's laws and the act, and I think that, it falls under other disciplinary action, and a person can essentially agree to anything in a consent order. I mean, as long as it's within a reasonable scope of the board's authority. So,
Interesting if you could get an example of the A&E take-home exam.
Well, I mean, I think that the scenario I proposed was what they do. I don't think that theirs is confidential either, but they also send it home. So at that point, I mean, the confidentiality is also an issue there. My whole point in saying that was just to say that it still causes the licensee to have to refresh their memory about laws and rules, which I think is the board's whole purpose behind doing this.
I think Josh has covered what we asked him from the last meeting. I think you've done a fine job. Thank you. What I do think the board needs to consider, we need to consider, is the necessity of this particular case. What is the purpose of the examination? The purpose of the examination is to ensure action and the applicant to renewal is aware and is familiar with and has proven that they know the laws and rules as published. Don't know that the need for confidentiality is there in that particular case. They've proven that they were a professional. The objective really is to ensure that the applicant is aware of and what the necessity for the confidentiality behind that is. But honestly, I don't know how often this exam would be given. If it's given the internet back and forth together or not, but
Wouldn't it almost be a good thing if, say, hey, did you know that such and such rule really reads da 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 da, and they shared the information, and it was, it actually, they actually spread the message instead of,
and
like, we
obviously
kept it like a secret.
what you don't want to happen is like in the fraternity house, file cabinet of the old exams, you just go A, B, C, D because it said A, B, C, D. You're not thoroughly researching. Professionalism is what we're after, and I don't think that would happen in this case. I respect and I understand the need for confidentiality, the desire, I should say, for confidentiality. I just don't know that in this particular examination warrant.
And that's part of why I said that I'd like to kind of see what A&E's doing, to see
sure,
if
yeah.
it's, see if they're asking for 3 questions or 103 questions or, if they're multiple choice,
Right.
just whatever the scenario is, because, as we've done in the past, Josh, before you came on board with us, we for a lot of things that A&E does, because they implement their licensure to a larger group of people. So it's good. They've already, they've kind of hit all the potholes in the road a lot of times for some of the things. So we do mirror them a lot. And that's why I suggested that we could if we could kind of see that, maybe we could kind of wrap our arms around that and tweak what we got or whatever it is and go from there.
Just from a contract perspective. Issues to evaluate over the next 4 years if we don't.
Well done, Josh.
Will you follow up with A&E to get us something so that we can further continue this discussion maybe in August?
Certainly. Donna, maybe we can work together to get them a copy if John's okay with that, and then disperse it to them individually maybe after this meeting, and then they can have time to review it and have questions for the next meeting.
Next is the QBS.
That's me again as well, I believe. And being new to this board and new to some of the terms and nomenclature, I've done some research on QBS and what exactly that entails. I don't see, anything specifically. I think that this comes up a lot with A&E again, because there's a specific statute under Title 12 that mentions architects and engineers and the QBS selection process for municipalities regarding their obtaining professional services for public projects. I don't, there's no specific mention of land surveyors. I don't know, there's never a definition given in Title 12 of the term that they use, construction services or other construction services, I believe is how it's phrased, other than architects and engineers, and the whole rest of the language of the statute only addresses architects and engineers. So, architects and engineers doesn't have any authority over that particular title. It's just that they're named, and that process is to be followed by municipalities. And I don't know if the board wants legal, myself, and probably my supervisors to form a more formal opinion on, our interpretation of that and bring it to you to see. I guess I'm trying to figure out what is the board's desire. I mean, at the last meeting, I think that my understanding was the board wishes to know if they fall under the Title 12 and regarding the bidding procedure under QBS. Is that, am I going the right direction, Mr. Lingerfeld? Okay. Yeah, I mean, I think at this point, it's a little bit deeper of an issue than I first thought it was, and I think it's going to require a more research. First of all, I went to the there's a municipal technical advisory service that provides legal advice, legal information, guidance to smaller municipalities in Tennessee. And they had some pretty good information regarding qualification-based selection. And they have this is only a guideline. I mean, nothing in here is authoritative. It talks a little bit about the Brooks Act, which is a federal law that states if there's federal money involved, then QBS has to be followed to obtain professional services. And then I think that the stance of a lot of professional organizations, such as, you're familiar with MAPS and American Congress of Surveying and Mapping, they endorse QBS. And I think by my reading of this, that MTAS is, endorsing it even for non-federally funded projects, but it's nothing that's stated, flatly that it shall be followed. It just is their suggestion because there's a lot of, industry support, and it is seems like a good process for obtaining quality services. But again, there's no AG opinion that I found that specifically states, or defines what construction services is, or in no mention of surveyors specifically within that. So I guess the first step is, if the board wishes, we could provide, legal's internal formal opinion interpretation about it. And then, there's always the option to seek a formal opinion of the Attorney General. And I could certainly help with formulating questions. That would be probably the final step, is seeking an Attorney General's opinion on defining that, so that we have an answer one way or another, once and for all. And there's just no formal opinion on it out there that I could find.
Well, I guess my concern was one, finding out whether we might fit in. I feel like that we do personally, but, you've spoke to it relative to the law and statute, so that was my first concern. My second concern was, if we didn't fit in, what's the best, or if that question still abodes, and I think it does, whether we fit or we don't, what's the best route of pursuit? Is it to look at it legislatively, or is it to go through the AG route? Because, seems to me there's more risk in a way through the AG route than there is legislatively, per se, because if the AG says no, then that makes it harder to overcome.
Yeah, well, that's always, there's always that risk by going to the AG, but, if you get something done legislatively, which, I don't know how long that would take or the chances of that happening, but even if you do, then that would probably, I guess you could have the lobbyists and the legislature try to get together and craft some language that would expand Title 12. But it would take expanding Title 12 at this point, and since we don't have, or I haven't been able to find a definition of construction services, then I think that's probably the question that you need to ask the AG about what's included in this construction services. And I think the federal law, the Brooks Act, was amended in 1988 to include specifically land surveyors. The problem is that I don't see the state equivalent. And there's no, like I said, there's no definition of construction services within Title 12. So that may be the question that we want to pose, that the board wants to pose to the AG. But I would ask the board, to give me a little bit more time, maybe bring you some more information at the next meeting, because, like I said, this issue is deeper than to be honest, I didn't realize how deep it went until I started researching it. But I think that I could get a more formal opinion written up to you about, at least from legal standpoint, and then we can see what the board wants to do from there.
What would be involved in getting a definition for construction services?
Well, you just have to submit the questions to the, get it certified at the AG's office for a formal opinion. The only danger there is we want to make sure, and I would certainly help you, we just want to make sure that we craft the questions specifically enough, because they won't go outside the scope of the question, and that's the only question that they'll address. So you
Does
have
the AG
to
allow you to give them historical reference, such as the Brooks and?
Yeah, I believe we can. Yeah, I believe we could include that. They, should be aware of that, but I think that we could make them aware of that.
I feel like that would carry a lot of weight.
Right.
Because of just the way you said it a while ago.
Mm-hmm.
Because the feds did their thing, but the state has not moved forward.
Right. Well, and we don't know if it's actually included in that or not, because there's no definition. So that's my main hang up there. But yeah, in crafting, anytime you craft questions to the AG's office, you always want to make sure that you ask the right follow-up questions, because if they answer the first one in the negative, then you want to know what the alternative to that is. So that's my only advice there. And, legal would certainly help. I'd help draft those questions so that,
We still have an AG opinion from '04 on drainage for surveyors that hangs over our head. That's
right. Yeah, I did see that. But I mean, at that point, when we're just seeking clarification, I think that's, I want to do some more research in it and give you our final formal opinion in-house, and then we can see if we want to move forward after that. But I'm just trying to think out down the road.
Oh, yeah, we appreciate that. Well, let's just do that.
Appreciate the extra time. It's just, it's going to take some more digging, I think.
Well, as you said, you didn't realize it was quite as complex until you got into it.
Right.
It's often very easy to ask what seems to be a simple question, but is not.
Right.
And I'm guilty of a lot of that. Okay. Next thing we have is the TAPS Committee report. Mr. Jimmy.
Thank you, Mr. Northcutt. As always, we appreciate the opportunity to be a part of these meetings and work with the Board of Examiners. Been busy since the last meeting there in January, and of course we all had our conference. Had several, I think it was 19 attendees at the review workshop for the land surveyors review workshop. I forget the exact numbers, but I think there was had 19 attendees, and it was about split. Roughly half were taking the fundamentals, and about half were taking the PSTS exam, approximately 50-50 on. Had some discussions and are looking at possibly revamping the format of that review workshop, so we're going to be looking to have some meetings and maybe revamp that entire workshop with some guidance. How the NCWS structures the exam. How the test is evolving, because our workshop's several years old. Has not been any further discussions on the GPS RTK standard since we submitted our report in October. I did receive some last minute comments there at the January meeting. Haven't had much of a chance to get into those too much. I do. At some point there's going to be some discussion at that at the board level. We definitely want to hope that would be a open dialogue where we can work with the board on what kind of standards or policies you guys want to put in place, so that we can come up with something that we can kind of keep it simple, but definitely get enough metadata on the plats to make it easy for surveyors to retrace those GPS surveys. And I definitely would like to volunteer to help with that. I use GPS quite a bit in my practice, so definitely want to be a part of that process. Have not heard anything. Was asked at the conference about any other discussions regarding licensing photogrammetrists. I've not heard anything else other than the report that we had, I guess it was late last year, on the committee, the ad hoc committee, or the committee that reported to this board here. I don't remember exactly what meeting that was, but I've not heard anything else on that push since that committee reported. Other push towards that at this time, or what the board stance is on that issue. So I don't know if that's something or if that's what the board's position is on that at this time. They may action or see if that committee is still standing, or if we need to discussion.
Well, we asked that committee to go reconvene to give us some couple of emails between one or two of the members, and right now, best to be considered on that committee. We'll talk about that also. See about getting some more response back from that committee.
I know Mr. Mormon was on that committee for the GIS and photogrammetrist. I know he was on that committee for that. My volunteer, me personally, I'd like to volunteer on the GPS standards, the GPS, discussing that. I know there's been a lot of discussion coming up at our local meetings and at the it came up at the board meeting there at the convention about the standards of the book. I know there's been some talk about needing a new publication, whatnot, about reissuing a book here that we all refer to as the Blue Book. Don't know if there's plans of ever publishing that, if that's in the state's plans for the future. If not, would maybe start a dialogue between the Board of Examiners and TAPS about the possibility of maybe finding out the hurdles maybe we would need to overcome to possibly, maybe if the state is not going to, if that's not in the state's plan or the board's plan to be able to publish that document, maybe to coordinate with TAPS so we could maybe take that on and publish that and make that available to the surveyors, maybe in our membership directory or something. Coordinate with the state to make sure it's accurate information. But we do know that there's a need for that document, a real need for that document.
Well, I appreciate you saying that, and it's still the board's desire that we have that published and made available to our surveyors, because you just held it up. Tim has his. I have mine, Jay. And carry it with us, and that's just something that we all refer to. And I think it's surveyor have a copy of that. There's no denying that the book, they have the rules, and so if they have any questions or any violations, or there.
Mr. Chair,
So,
may I address?
well, and I just think TAP's requesting to do that, we will have to go through legal because of the requirements of what goes into this thing and make sure that nothing is left out and that kind of thing. So, Nicole, you can probably go beyond that.
I think I can answer that. The entire Commerce and Insurance has gone through a contract change from LexisNexis to Westlaw, and it's not just one board, it's all of the boards. So it's quite the conversion process, but we're going to be able to, it's strange enough, we have to gain the rights to print our own documents, but when we make the conversion, we will be able to print new books when the new Westlaw contract goes into effect.
That's good. What time frame are we talking about?
That I'm not positive, but it shouldn't be too much longer.
Much longer.
It's been
2016.
It might be that long. I really don't know exactly when the implementation will be. It's not just one board, so it's a big hurdle to bring not just a board but an agency worth of laws and rules all at once to be able to make them searchable, fillable searchable PDF documents, and then be able to also print them into bindable books. It's not as simple as it sounds. It's not like in the old days where you just got to print the old blue books, at a print shop. It's not the same thing. It's a totally different animal now. So now you'll be able to get like these things that you put on your iPhones, and you can just search GPS.
Not looking for an official answer, but I'll ask it to Josh because it does have some legal implications. Publishing costs. Let's say TAPS goes out and produces, goes through a local printer, $10 a copy, TAPS sells it for $10 a copy. Is there anything that precludes them from?
I mean,
I'm not putting you on the spot.
no. To be honest, I don't know.
Okay.
There may be some hurdles there that I'm not.
I didn't know if it was a copyrighted document or anything like that, but I did.
Document, I think you'd have to go to LexisNexis and buy copies from them if you wanted to purchase them.
Similar to what you said earlier.
Can't technically print them. They're on the internet right now. You're welcome to.
I do kind of wonder about that just because it's, it's the law, it's the rules. It seems like it's a public, but I don't know. I mean, I guess we can't do that because
Yesterday, went to the board website, found the rules, PDF file, sent them to the printer. Here they are stapled, right here.
Apparently that's been a change.
Technically, you're not allowed to.
Technically, I guess I'm not allowed to.
Apparently that's a change since this last one was
Yeah, I know.
was printed.
It's one of those catch-22 things. It is a public document, and yet there is a company that produces that document, and they have it copyrighted. So we have to be more, as an agency, we have to be more careful about producing the document.
I guess it's different when you go home and use your own printer, and
it is different.
you're not making profit off of it. So
Yeah, and so I would not, as the director of an agency, advise TAPS to go and do that.
At this time, it's technically copyrighted, even though it's a public document. So there are some legal hurdles to overcome at this time.
But it is coming, and I would say it's longer.
So if I understand you correctly, and tell me if I'm wrong here, is it the anticipation? Book, thank you, a physical, tangible book. Okay, that's all I need.
That's what you wish. You may spend your money how you choose to on that particular item.
I believe at this time, that's probably all we've got. Is there anything that, I would like an update you on this. I do know that, I believe that Mr. Jerry Taylor has submitted a ethics seminar, and Ms. Donna may know this. I believe he has submitted the ethics seminar to be reviewed for approval. I want to say he submitted it. I think he said he submitted it. I know I'm in the process of putting together some, the minimum standards, and it was suggested that maybe I include some examples of plats and whatnot. So rather than try to pull them off from one geographical area, I'm gonna try to get some examples from across the state. So I'm gonna try to get some of the TAPS BOD members to maybe help me pull together some different examples of maybe some plats that may have some information missing. My plan is to have that submitted in the next month or so. So hopefully we can have that, hopefully for y'all's approval by the July meeting, so we can have all of our I's dotted and T's crossed. So once the January 1, 2016, once that new time period starts for the minimum standards and ethics, hopefully we can have all of those two seminars for TAPS submitted and approved, so we can start offering those at the chapter levels.
I'd like to just, as a member of the board here, me personally speaking, I'd like to encourage TAPS to do that post haste. Out there available to the members, to the surveyors of the state of Tennessee. If it benefits TAPS, great. But the point is that for the ethics and the minimum standards, we need a vehicle to heartily encourage TAPS to get that in the works.
Like I said, we're just going to add some plats, and we suggested we add some examples in, for some maybe to generate a little more discussion as opposed to just reading the standards off of a slideshow. I hate being read to, so maybe try to generate a little more discussion during the presentation. So I thought that was a really valid and well received comment. So that's all I've got right now, unless there's something that the board would like to ask us to do to help you guys.
Cleveland, I don't think of anything right this second, but before the day's over, something may come up. So, but thanks for your report, an excellent report, and appreciate the work that TAPS does and for our profession, and obviously what's done helps this board.
If something comes up, I'm just a phone call or email away. So, thank you.
Next item we have is create a board policy definition for principal as used in the new rules of conduct. And I know Tim and I talked about this. In fact, I guess Tim and Jay probably have talked about it, and so we've had a discussion, but that's about it. And
Document that's been handed out to us, was that crafted by Josh or?
No, by our office.
I just had, just a brief moment, obviously, to read this over once. I don't, personally, I just don't feel comfortable making a final policy today, just having this placed in front of me like this. I'd like some time to be able to reference some other sources, perhaps other states have,
Our main questions that we're asked are, is the principal surveyor in the company, or is it an officer who is the principal officer, or to be able to tell them?
Absolutely.
This was just meant to be a starting point,
Yeah,
so
yeah.
we just wanted to make sure that you didn't have to start with nothing, so.
Well, I think the intent, and I know Donna, I saw a question on it. I think our intent with this was to make sure that we had a registrant.
Yeah, yeah.
But I think where it got entangled was this particular section, this language came from NCWS model rules. Polish it enough when we inserted it, so that's why we need to give definition, kind of like what Josh was talking about earlier when we was talking about QBS. We need a little definition of something, and I think that's what it is. That because I know there's a question out there that said, well, I don't want to be a principal or officer of
Right,
the company,
right.
but I want to run this office.
Right.
Well, they can.
And that's what their concern is.
Yeah, and that's one of the major concerns. In this draft, I was concerned about also a sentence that said an officer or principal may be in responsible charge of more than one firm only if the firm's at the same physical location.
I think that's the rule.
I
That's
couldn't
in the
remember that
rule.
in there.
Isn't it, Josh?
I didn't remember that one being in there, but it may be. That was the two rules I didn't put in my folder to bring with me this time. I had them and I just laid them out before I closed it up. Anyway, that's the main purpose, is just to have that licensee in that office.
I don't see that, no.
I agree with Jay. I think this is something that we probably ought to take and all over a little bit and tweak and massage and that type of thing.
Yeah, just take that.
Not in the
That should
rule.
be
I
in there.
I'm a little hesitant about allowing one person to be the principal for more than one firm, even if it is at the same location.
I think when we wrote this, we were looking at something else, and that's not supposed to be in.
That's the first thing grabbed me when I skimmed read it real quick.
It says in the rule, I'm just kind of thinking out loud, it says, provided that at least one of the principals or officers of the corporation is in responsible charge. Well, I mean, the firm, the company just needs to make a decision about who that person's going to be, and they need to be a registrant, right?
I think that's where we need to have a definition for principal, basically, yeah.
Oh,
Yeah, I think that's,
I-
I think that's the key, because right now, I know Donna was crafting a form for, firm registration, and it asked who the officer was as a registrant, but what we're running up against, Josh, is that we have firms that the principals or officers may be registered surveyors or may not be registered surveyors, but they actually employ a registered surveyor who is not a principal or officer, and they actually run that entity.
And that's what I tell them.
Yeah.
If you're the principal surveyor in that company, you need to fill one out.
So I think we just need a little clarification of that. And it may be no more than that, as opposed to 2 paragraphs or whatever.
I mean, my only caution is, I always kind of caution against policies, even if they are written. I mean, I think at this point we may be able to add, a subpart or something to this rule or to this chapter that would define that better. Because I think we still have rules that are working their way through, so it might not be that big of a deal at this point in the process to add a rule. But that's just something that we need to look at, and I'm kind of with Jay on that I'd feel more comfortable having, trying to craft something, making sure that it's exactly what we want, especially if we do a rule or a statement. But yeah, I can understand why that might be causing a little bit of confusion.
That was also a question that I had that I guess we may get to, was what was the status of the last rule that we were working on?
Those rules are still working their way through the process. I think I've got something today that I was going to get board approval on, which is going back to that military applicant rule that the board had.
We haven't got to it yet. Don't let me.
No,
get you out of
I don't want to
sequence.
get. I don't want to get out of sequence. It's not a huge deal. It's all the boards are going to that military applicant rule, as you know. But I think that the language as presented to you by my predecessor wasn't exactly the language that we want in the final product. So I've brought that to you, and all I need is just a up or down motion on that, and then I can proceed with the usual rulemaking.
Okay. And like I say, we may want to tweak something like this and pitch it in there or something, because that's sort of a catch-all rule anyway, the one we're working on right now.
Right, right. I just, at this point, it's probably the best time if we want to tweak anything, because it's not just a matter of tweaking something from this point forward. I mean, once it gets approved through the department, then it's going to require a lot more legwork to get anything tweaked. So yeah, I think it's best to get everything in there on the front end before we start the ball rolling again.
Table this particular issue until we're
I'll get that for the next meeting.
That'll be fine. Question about it. All right. Next item I have on here is to discuss the future of the Tennessee specific exam and how it'll be administered after October 2016. Tim, I'll address to you, et cetera.
Well, I guess I'm responsible for that. A couple of things. It has been decided by NCAAS that October 2016 will be the last paper and pencil administration of the PS examination. After that, effectively beginning January the 1st, 2017, it'll be CBT, which is be the same similar preparation as the FS examination. At which time, they're considering, effective January 1 of 2016, NCAAS is considering eliminating this 1 month window that's off, two test windows, and then a 1 month off scenario through the year. They're considering making it where it can be taken basically any business day of the year. So if FS goes that way come January the 1st of 2016, then PS will fall into that mode come January the 1st of 2017. So the person will be able to take either exam, whichever they're qualified for, on any given day if there's, if they're approved by their appropriate board, jurisdictional board, and if they have a seat for that specific day that they choose to take. Crafted about similar parallel to the FS about taking it 3 times, so forth, in a 12-month window, so forth. This board will be dealing with kind of another new creature. Same old test given in a different way, but the reason I bring that up is, one, for notification to the board, so that everybody's on board with that. Number 2 is this also affects the contract that we have with our exam proctor. Proctor is aware of how this cycle is going. He's already familiar with the fact FS has dropped off, and now he's familiar that PS will be dropping off. Now, his contract runs out, to the best of my recollection, in March of 2017. So one of the pushes between now and the time that the PS goes to CBT is for each jurisdictional board to determine kind of how they're going to continue giving their own specific examination. Obviously, NCAAS is desirable to them that the state boards could get on board and give it in some type of CBT format. But as you well know, when you have, we have 66 boards that's in that many boards of anything. Part of them are dual boards and part of them are not. But at a minimum, there would be 50, actually 51, because District of Virgin Islands, Puerto Rico, et cetera, et cetera. But anyway, with that many different examinations, you could see where it would be problematic being CBT, because the laws and rules in Tennessee are not like they are somewhere else, and vice versa. So that's a major topic for NCAAS right now, with the surveyors and the PS committee, which I happen to be on. So they're trying to assist each jurisdictional board every way they can to determine where we go from here. So in other words, effectively, come January 1, 2017, our exam proctor would administer no more exams prior to his contract running out. So come April, if we stayed on the same scenario and cycle we are, we would have to have a new contract. Our Tennessee specific examination. Part of the encouragement with PS going to CBT is to encourage that if a individual, because now what's happened is, historically, many years ago, and a lot of us in this room actually took all 3 examinations in a 2-day weekend. Once the FS broke away to CBT, that changed all the scenarios. Now you take the FS, and then you can take the PSTS. Well, now you're going to take the FS, then you're going to take the PS, and then sometime later you're going to take the TS. So now we have a whole new creature as far as exam scenario in order to get to the end result of becoming licensed. So that's part of why I brought this up. Obviously, we're not going to act on anything today or anything of that nature, but it's knowledge that not only we as the board, but Donna and Nicole as a staff needs to know so that we can be looking ahead, so that, as I always say up home, we don't get caught with our britches down when the time comes. So that's kind of where I'm looking at, because, you know, I feel like that sometime early 2016, this board should hopefully be able to make some kind of decision of how they want to continue that administration of that 2-hour examination. You know, some board offices actually give the exam in their office. For example, Michigan and Utah use a parallel exam, and they give it CBT. It's not through Pearson VUE, it's through another company, but they give it that way. So there's, I guess what I'm saying is there's all kinds of scenarios of how these jurisdictional examinations are administered.
Exam multiple choice, or is it essay?
Our current exam is both. And that's another reason why I mention this, is because this board, I know, has not had a scheduled meeting with our exam proctor since it's been this several years ago. Sue probably could remember when they did meet with the exam. Had basically closed session per se to talk about the questions, the structure, and so forth, so that it wasn't, you know, a public record, you know, because it's a secure examination. But that's something that we need to look at as well, to determine, you know, if we want to make modifications in the examination such that it's, let's say, applicant/staff friendly, if the staff would decide that they wanted to proctor it, you know, in building, that type of thing. That's something, again, not only the proctor scenario, the administration scenario, and the content of the exam scenario. All of those need to begin to be thought about and worked on in order to get to where we're going come January 1, 2017.
If you want to convert the Tennessee-specific examination into a multiple choice exam, which I encourage you to do so, and we switch it to a computer-based test, I would advocate for having it in-house and us proctoring it throughout the year. I think that's an idea. I think we should do whatever we can to streamline the process for our applicants, so that if an applicant has met all of their education and experience requirements and can pass all possible, so that, you know, we do what we can to support commerce in the state of Tennessee.
That's the ultimate goal, and I certainly agree with the direction you're coming from. The other thing is the paramount weakness that our current TS examination has is that CBT with that examination, we don't have near items in the item bank in order to support, because when you go CBT, you need to have a cyclometrician involved such that the items can be analyzed to make sure that they have all the proper P sub syllabus and all them kind of values that they go with all that stuff. I've been through all them classes, but anyway, they have to have all that kind of stuff. You know, they have to have certain number of detractors, and you need certain per category, so forth and so on, just as the FS and the PS are set up. Now, obviously, we don't need that quantity of an item bank as the FS and PS, but we need an equivalent quantity so that if in fact we were given 2 or 3 exams at the same day, that those exams are such that if the 3 of us were sitting in front of 3 computers taking the exam, we're not looking at the same question, same time, the whole 9 yards, all that kind of stuff. But that's a security issue, obviously. But yes, you're right. I like the direction that you're thinking, because that's kind of the direction I was trying to think. And but the item bank is probably one of the most critical parts. And in order to get to that point, in the future being January 1st, 2017.
I've worked on a national exam too, and it was quite the past. I was a subject matter expert for the appraiser examination, and just actually more difficult to write the distractors than it was to write the questions. I'm with you, so I know how difficult it is, and just constantly testing those questions to find out if they're fair, if they're too easy, and how difficult it is. But it's worth it.
And like I say, that's where we're going, and I like where we're going. It's just that we have some work to do to get there, and I think we're all willing to do that and jump. I wanted to kind of report on that, and that's why I had that item on here, because it's never too soon to, begin discussing things of this nature, knowing that they're coming.
If I might add, I took the Missouri exam. Actually, unfortunately, I take it twice. But the first time I took it, we were the last group that took the 2-hour exam in a 2-hour block, and it was the administrative code and of course, Missouri being a public land state, it was all one 2-hour exam, and then those of us that had to go back and retake it in that following spring, they had broken it up. It was a 1-hour administrative on the rules and regulations, and then it was a 1-hour with the public lands part where you actually did the math, and it was still a paper test. It was still a paper test, and then just back in January, and that was given in conjunction with the twice a year with the NCWS exams, but this. Excuse me, just recently with Kentucky in January, Kentucky administered it when they had enough people. I think there were 7 of us that took the exam, and they gave it there at their office, and they had one of their staff members administer the test there. So, but just to give you a background of somebody that's taken a couple of tests just in the last year or two, that's how 2 nearby states have done it. Just to again give you a little information on taking it recently. So, but I mean, I thought it worked pretty well. So.
Thank you. We've got a pretty good support network. The MBAs at NCWS are working on this. The NCWS is looking at the ability to get the applicant quicker in a more professional way. A lot of things that's part of this equation that they're working on, and there's a lot of folks working on it, and a whole lot of folks a whole lot smarter than me. But I just want to kind of just run this by everybody so we can kind of say, hey, look, we thought about it in 2015 and we got to work on it and we're ready. Just like when we changed some of our language about the exams and stuff in our law, we were ready. Always bodes well, for us, the applicant, and also through NCWS too.
Break for a couple of reasons. So it's 11:30, and I think that we need to break for time for lunch, and we'll be back. Now 6 minutes after 1, and we'll reconvene our board meeting, and we have a guest with us, so we will need to, whatever we need to do with our engineer compatriot here. John?
Yes, I think y'all had questions about the regional meeting that we're hosting next year and our announcement of that or invitation to that meeting at next month's regional meeting. Is that correct?
Yeah, just more of a fact finding of what you got laid out, and because we're sort of part of it, maybe.
Yeah, I have contacted the Convention and Visitors Bureau. I haven't heard back from them yet, but I just did that today though, so that's probably why. So anyways, but yeah, we'll get some materials from them. I'm sure they have some attendance building materials that we can hand out at this meeting in Scottsdale next month, and a video that we can show, typical video showing somebody playing country music probably. Now, as far as who's going to actually do the invitation, I asked the engineers about it. They were sort of indifferent. We'll deal with that when we get to Scottsdale. So, I mentioned Tim maybe doing it, but yeah, the engineers are just kind of like, yeah, we'll deal with that when we get to Scottsdale. And it is on the last day of the meeting, at Saturday, when we actually do the invitation right at the end of the meeting. So we've got time to talk about it, I guess, when we get to
Be there
Scottsdale.
because of Tim's flight schedule.
Oh, you won't be there Saturday?
I'll
Okay.
be there Saturday, yeah, but they've got me leaving really early in the
Oh,
day.
okay.
Yeah.
So it'll be Jay.
Leaves like at 1 or 12:30 or 1 or something. Tim would be glad to do it, but I won't be there.
Well, Hal will be there, so I'm sure Hal could do that. Several of us, of course, can participate in that. So that's the plan. And of course, the meeting will be at the Lowe's Vanderbilt Hotel on April 7th through the 9th next year. So it'll be earlier in April 7th through the 9th. That's just for the Southern Zone. We're not doing a joint meeting with other zones like this year's meeting. So, but I've been told to expect around 200 attendees, more than likely. Southern Zone has the best attendance of any of the regions at their regional meetings. So, of course, we've already got the hotel contract in place. And, the invitation's in the works, but everything else we've still got to do, which includes finding a speaker for the luncheon. So be thinking about that if you have anyone in mind to speak, someone to do a welcome. And I've talked to our Assistant Commissioner, Brian McCormack, about the possibility maybe of the governor coming and doing a welcome. It's just going to be down the road, so we'll see. I'm going to ask. It never hurts to ask. That'd be nice. We'll have to do some entertainment. We'll have to do tours for the guest. So there's a lot of planning to do, but nothing that we have to do immediately. It's in the coming months.
But do you think that part of your staff or our staff will be able to be involved or whatever to assist?
Yeah, definitely. Yeah, we'll have to have staff there to man the registration desk, hand out materials, etc. So, yeah, my staff will participate. I'm sure Donna will be there, and maybe one or two of your staff people could help.
Like to put a conference on here in Nashville.
Tips are welcome because I'm not a meeting planner. That's not really what I do. So other than board meetings, which is quite different from this. So yeah, I definitely welcome any help you can provide. And it's kind of unfortunate it's at the Lowe's because it's so far from the downtown core, but they had the best deal and NCWS thought that they could best accommodate us. So that's what we have, but yeah, there are going to be, I think, more transportation costs associated with us being out there versus downtown. And it's not as convenient for the attendees. Obviously, everyone's going to want to come downtown. They're not going to want to stay around Vanderbilt. So, but that's, don't have any control over that. And I did have another question for you, unless you want to have any other questions about the zone meeting. An email from one of my engineer members, Robert Campbell, that he received from another engineer, Robert Garrett, about subsurface utility engineering. And he says that he's working on a couple of ASCE committees related to subsurface utility engineering. One of these is the committee to update ASCE 38-02 standard for depiction of existing utilities. A question has come up about which states allow engineers to seal subsurface utility engineering survey sheets. What is the current stance in Tennessee? Are these considered survey documents or engineering documents? what are engineers and surveyors allowed or required to do? And my board, the engineer committee, discussed this, and they said, we'll defer to the surveyors board on this question. So I sent it to Donna, and she was going to bring it up in her director's report, but somehow
I
it
meant to.
didn't make it in there. So
Yeah.
I'm bringing it forward to you now for your discussion.
Don't you?
Well, is that a can of worms? I'm sorry, I didn't know it was.
Probably not. That's what we dig for. Thoughts?
My initial thought is I'd want to see really the question and the setup there that he read and have an opportunity really to kind of fine tune it.
All I have is what I read to you, so. But
Get a
I
copy of that
don't
or
have the
something, just get an
standard that he's
opportunity to
talking
study,
about.
It'd be great.
Yeah.
You may have.
I thought I did.
What you emailed to us?
I thought I did.
Yeah, I'm pretty sure it was. For it.
I didn't
I
see
may
that.
not have.
I did not see that question.
How deep
We
was
have
that
questions.
into
I
this?
don't know.
Reading it, but doesn't mean it's not there.
Email it to us, Donna, or whatever, and we'll research it a little
No,
bit.
it would have been in the packet that I sent.
No, I mean, I said, can you email it?
Oh, can I? Yeah,
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 just-
yeah. I just forwarded y'all the email that John
Tomorrow,
sent
or
me.
Monday or something,
Yeah.
or whatever. And we'll look at it, John, and
Okay, that's fine,
then discuss it, get back to you.
yeah. The engineers don't have a position on it, so it's just entirely whatever you decide on that.
It's almost like, an idea that Northcote's putting out, and it seems like that's what.
We have to look at it too, how it relates to, for example, a boundary. Probably is going to relate to something, and if it does, it may fall under our definition, but we'll look at it and see. Thank you for taking time to come see us. And,
Sure, no problem.
and,
Guess I'll see y'all
give
next
us a-
month in Scottsdale.
give us that update.
All right. You're welcome.
All right, then.
Y'all have a good meeting.
All right. Thanks, John. Next item on here is discuss questions to the rule changes.
Just so that legal counsel can get this,
falls under rule changes. I've got, this is kind of what we touched on earlier. I've got a printout of the new language for the expedited procedure for military personnel and their spouses. I'm just going to pass this.
Gosh, we had seen something similar to this before. Is this the same thing, just copied again, or is there actual changes to it?
I believe there's actual changes, just, that's what should have been presented to you previously, but I think that not all of it made it in there, at least in the copy that I saw that was, had started up the chain through rulemaking. So basically, I thought prior to this meeting that maybe I could just show it to you and ask if I have authority to move forward with this, because this is the model that all the other boards have been using, and I've gone forward with it in contractors and a couple of other programs that I had prior to that, using essentially the same language, but I did start to have questions just as I was reviewing it just now about the temporary licensure language in there, because I'm not sure if that would fit under the land surveyor's profession just based on the amount of education and expertise that it requires. So that may be something that the board wants to take more time to look at.
We don't have any form of temporary licensure at the current time.
No, sir. This is,
It's not, would this, even though it's military related, would it not in effect cause a change in something else? So another part of our
well, I think that it's just,
statute rules?
yeah, I think that it's just, it's in there to comply with the Title IV, 1304, which is basically, calls for the expedited licensure of military veterans and their spouses. And I think temporary licensure in some programs or boards, it works better under theirs. And it may be something that you guys want to look at, and maybe we, discuss it more in depth at the next meeting, just to give you time to look at it and kind of roll it around. I'm not sure that it absolutely has to be in there to comply, because I know that there's certain programs where I think they're not doing temporary licensure, but they're still doing they still have to do the expedited, process.
That's the only question that I really have about is about the temporary licensure, because we don't offer that to,
Right.
to John and Jane Q Public as it is now.
Right.
So I don't know why that unless we change something else in our statute, why we would offer it just specifically to military. That would be.
Well, it's just done in an effort to try to get them to be able to work in the state if they're relocated, I think. And then, the temporary licensure has certain requirements that still have to be met, such as education and getting experience up to our level. If they don't meet that Part A, which says that they'll have substantially equivalent requirements that they've already met in another state that are substantially equivalent to ours here. So, I mean, yeah.
This applies to all programs and regulatory boards.
What you're saying is it's boilerplate language and it's all or none. That's what I heard you say.
All of the programs have to adopt this language.
I have no issue with the military part. I'm just have the issue with the temporary part because we have that nowhere in our law.
Right, but
So-
the
Yeah.
legislature says we have to do it.
Yeah.
If they
The issue-
passed a law that says we have to have this for military,
What I hear you saying is contrary to what I hear Josh saying.
Well-
Josh saying is we can look and see about the temporary language, but you're saying there's no look and see about it.
I was under the impression, and maybe I'm wrong, but I thought that there were certain, am I wrong there?
I think you're wrong.
Well, I will say that, yes, we have to do something to expedite the military applicants.
Certainly,
And
I have
that
no
is
issue with
right,
that.
right. And, I was trying to pull up my email here because one of my supervisors Tony had emailed me something about the temporary thing. And I just got a new phone, so I can't get on the, I can't find,
technology.
I know, I can't find the,
If
can't
you're
find
a young
the,
guy, I could understand if it's one of us old
well,
guys.
I usually just Google it and it pulls up the web app for the Outlook, but I don't have it. But anyway, so now I feel like just kind of put my foot in my mouth because I'm sitting here, I brought this to you. I just kind of wanted to get it in front of you at least so that we could be looking at the correct language. And I think that a lot of this was left off of what was presented to you. And if it wasn't left off when it was presented. It was certainly left off when it started to make its way through the process.
So basically, do you want us just to give you a nod that, to
Approval to go
proceed
forward.
with this?
Mhm.
And can we throw in that nod that, something about it, and an investigatory scenario for the temporary licensure?
Yeah, I mean,
Would
I'll
that
be
be
looking.
fair?
Yeah, I'm going to look into the temporary licensure part to see if there's any exceptions to that. But Nicole is right when she states that we have to do it. It's mandated, and all the other boards and programs are adopting language.
I just didn't
like
want to
that.
be in the have-to situation, and it's actually changing something that we don't even have. That's the only thing, because
Oh,
I don't
yeah.
think that was the intent of what they crafted here.
Right. Well, I mean, I think that by that statute under Title IV that it could potentially create some pathway for temporary licensure, but that's something that all the boards have had to be, wrestling with, because I know a lot of programs and boards didn't have temporary licenses.
All this is to say that we have to create this specific section in our rules. However, I've already had this implemented in the home.
And I mean, I think that if that applicant does come through, even without this rule, we still have to do it. It's just now we're memorializing it in a rule to show that we're in compliance.
Right.
I think it's a real possibility that it could happen with the engineers and the surveyors board. Surveyors, maybe not as prominent, but, I'm not sure how many, would you say, appraisers and home inspectors there are in the military, but I'm sure there are some. But obviously, Josh, if you can look up the temporary status, I think that'd be great, but, I don't want to delay that.
Yeah, that's fine. And I'll be more than happy to do that. And I appreciate the board's time.
You need any kind of motion from us or anything, or?
Yes. Just a motion to, approve for rulemaking with the caveat that I'm going to look into the temporary licensure part.
So I'll make that motion, that we approve this for temporary rulemaking, and he's going to investigate the temporary just to report back to us, because he knows where we're at on that.
All right, made and seconded by Jay. Any?
Aye.
Okay. Back to the last question at hand. Discuss questions to rule changes.
Right. We answered my first question in the director's report. It was about the 2 years, the ethics and the standards. Was it 2 years 2 hours or 4 hours? We already answered that.
Yeah.
The next question is, let's see. I'm currently the historical chair and an officer for the next 4 years of ASPS. With me being an officer, active participation, will my participation be considered for 2 hours ethics or just part of my 30 hours? I would say part of his 30 hours.
Well, here, let's look at this carefully, the way it's worded. A minimum of 2 PDHs shall be earned by successfully completing a course or activity. I consider what he's just classified there as an activity that has content areas focused on surveying ethics and standards of practice. I would say that if he can provide a better definition of what his activities are, he's given us titles, but he hasn't given us activities, and how those relate to surveying ethics, then I would say yes, we would consider that. Fall under the ethics category. But I look at it like the things we looked at earlier today, you know, the itemized courses that they're taking. Well, I don't exactly understand what that is. The title doesn't tell me what that is. If he could, you know, phrase exactly how being an officer with whatever committee it is, historical committee chair, how that relates to ethics, absolutely, I would consider it. But I would say that he.
Next one.
Agree with that.
I agree with you.
How far is adjacent to, this is in regards to seals. How far is adjacent to seal? What about revision dates? We place the issue date on the drawing and the seal is near the certification.
Typical, seals near the certification. You know,
Know exactly what he's referring to, adjacent to seals. He talking about
it's a new
signature, the
change. It's a new
days?
change in the professional rules of conduct
Right.
under the seal that allows the signature to be adjacent to the seal as opposed to across the face.
Across the faces. Oh, good gosh.
Response would be in the same vicinity would be my response.
Next to, above, or surrounding.
Yeah, in the same vicinity.
Really?
Side.
Yeah, that's kind of a really nitpicky type question that's, you know, obviously, you know, if the seal is here on the drawing, you don't want to sign up here in the other corner.
Right,
I mean, you
right.
know, there's some logic to that, you know, I think.
Across the face and beyond the circumference of or adjacent to the seal on the document. Okay, so that's where it
We
comes from.
never had the adjacent to until we did the new rule.
Next question.
Is the seals and signatures printed in color from an AutoCAD drawing considered electronic? We print out our drawing on paper in PDF with the seal and signatures on the surveys.
That would be the seal would be fine, but the signature's not fine because the signature has to be protected. And the new rule specifically says how the electronic signature is to act and be managed.
Next question. Okay, we've already answered this one. It's about the principals, officers and principals and all that. Do you want me to?
Right, well,
The next one is what is considered officers and principals. I'm an employee, and not want to or desire to become a principal or an officer. Okay. Ooh. I am looking to expand my business in Tennessee. My staff all work remotely out of their house. I know that's different, but it works for a lot of Silicon Valley. In order to advertise a location as a corporate or project office address, what are the rules in Tennessee? Example, new employee or 1099 for first few months of test employment works at home. Is that address okay to be listed as a land surveying firm office on government solicitations?
I would say that the home address for the employee would be proper if the employee is a registered surveyor.
Yeah, number one, yes. Yes, the primary surveyor. Also say that all correspondence related to that company would have to address, as long as that RLS is at that address, and that is the, you know, the main correspondent. offering
Corporation
services.
would be
Yeah.
in violation there, the business entity would be in violation.
'Cause that's what I heard from the question was that this guy was, when she read the question.
But if he advertises, and that's what he said he's gonna do, in order to advertise, what must he do? So you're right in the spirit of how you understood the question, but now he's saying, if I advertise, what do I gotta do? Well, if he's gonna advertise, he's gotta have a registrant to advertise. Pardon me?
Shouldn't all that address be used as the? If he hires some other surveyor in there that's licensed with him, and then the mail's, y'all.
Well, here's an example. If I lived in Arkansas and I wanted to employ Mr. Cleveland in Tennessee, then he was gonna operate out of his house, okay? And I'm happen to be licensed in Tennessee besides Arkansas. But I need somebody physically in Tennessee and I want Mr. Cleveland to do that work. Then on the initial criteria, he's licensed. And two, he's got a residence in Tennessee. So he meets the criteria and the spirit of what we've now got under the rules of conduct. But if Mr. Cleveland was not licensed, then he did not meet the criteria and he's not working under my umbrella. Even though he works for me, I can't help him in Tennessee because Tennessee has rules that says if he is going to do that work and advertise that he's doing that work, he has to be licensed. I think that's what we're saying, I think.
Just remember, Donna, when you answer that letter, that
Oh, we go ahead and do that before we get to this last thing. Can we review these applications right quick?
I'm concerned, if the board agrees with that, that's fine with me.
I don't know how to talk to him. He reads it because I sent him an email.
Prove it without a picture.
Application incomplete, this guy don't have.
We don't have to require that it's on there.
Part of the application though, is it not? Send them an email that says, please provide a picture. And if they say no, then it's. Place of birth, Finland.
Yeah, I didn't know where it was from either. I couldn't tell by the. Put it back in here. Didn't have.
It ain't no neighborhood like that.
He's not from around here.
Oh, Cantrell.
This need a signature.
So, means.
So, U.S. citizen.
Work permit working, yeah.
It's in here somewhere. Up here.
I've got the, I believe to be the latest and greatest here, so.
I don't know that.
Wouldn't have changed.
Yeah,
Sue's already looked.
According to the form that he signed, and he acknowledged being a qualified alien, that we look at, not that you missed anything.
Didn't Florida?
The gentleman said, if I remember correctly, that's what I thought. Because he worked from '02 through 15. That's 13 years. That's
You can leave. You can go to the car and take a nap.
Board's discretion, so, yeah.
Jay.
She got a girl, Jackson. This is
Exit 407 that goes to Sevierville, Gatlinburg.
what do they do?
I was gonna say, I don't know. I guess they spend money. Had to be experts in engineering. Seen but one AS in the whole bid.
I'm done with my book. And what I don't want I stuck in there. I left his little booklet in his bag.
That's all of them.
Well. Now to redress, go back to where we were before we started. Discussion on the use of drones as it relates to land surveying. Discuss.
Well, I'll start it off with, we did have a little bit of a setback. You know, there was a legislative effort made this session that has since ran into a little bit of a hiccup with some other entities that got involved with it, the assessors and TDOT. And it won't go anywhere this legislative session. But I still think, in my opinion, speaking as a board member, I argument at least, if something like that were to come in front of us. But I do think that we need to make a concerted effort, regulations or through legislation, really, to make it clear and wanted to bring that up and kind of let you know where we are legislatively, or where. Also to get your opinions and your ideas on the product of a survey.
I think that we have, through the course of our standards, we have part of it that we need to have some legislation.
Off the cuff, I think it's something we definitely need to be, as a profession, need to. Top of it now, it's gonna be similar to the GIS realm. Already experimenting with it and doing some remarkable things with it, just more like a hobby right now, but
Okay. Oh, what?
Yeah, we were trying to, and this was not a board effort, this was outside the board effort, we were trying trying to amend that bill to get some language in there to the effect of if the drone or the product of, I'll say drone as a generic word, is used with the intention of the product being a survey, that it should be under the the supervision. All we were trying to put in there, and some other entities, like I mentioned, TDOT certainly had some involvement in there. They were interested in. And I think a lot of it just had to do with maybe my failed efforts to educate the legislators enough.
Item is review the fundamentals of surveying FS exam applications. So, already done it. Yeah, right, okay. Anything else?
That's it.
Okay. That was the next thing coming up here, so we started it.
Yeah, I want to see my baby on time.
Hour conference or two.
Who seconded this?